Hello everyone. Today in this video we are going to discuss about the topic quorum for general meetings. It is provided under section 103 of the Companies Act 2013. This is basically a very simple concept. However, being a very basic concept, many people confuses in this, that is quorum for general meeting, because there is a huge deviation from the provisions of under the Companies Act 1956 and the Companies Act 2013. So we'll be discussing what are the provisions regarding quorum for general meetings under the Companies Act 2013. So let's proceed. First of all, Section 103, subsection 1 of the Companies Act provides that unless the articles of the company provide for a larger number, in case of a public company, 5 members personally present if the number of member as on the date of meeting is not more than 1000. So basically, the first line indicates that if an article of a company provides for a larger number, then that larger number will prevail. However, in any other case, that is, if the article does not provide for any number, or if the article provides for a lower number, then in all those cases, the provision of section 103 subsection 1 would be applicable, which says that in case of a public company, 5 members shall be personally present if the number of member as on the date of meeting is not more than 1000. So if the number of members is less than 1000, then the quorum will be 5 members. Secondly, 15 members personally present if the number of member as on the date of meeting is more than 1000 but up to 5000. So if the range is more than 1000 member but less than 5000 members, then the quorum shall be 15 members. Thirdly, 30 members personally present if the number of member as on the date of meeting exceeds 5000. So if the range goes beyond 5000 members, then the quorum shall be 30 members. Okay, so let's look back. It says that in case of a public company, the quorum shall be 5000 if the number of members is less than 1000. 15 members if the number of members is more than 1000 but less than 5000. Thirdly, 30 members if the number of member as on the date of that meeting exceeds 5000. So this is the quorum. That is in case of a public company. Um, it's a slab that has been given, like less than 1000 or more than 1000 but less than 5000, or more than 5000. Okay, so three slabs are given, that is of 5, 15 and 30 members to be personally present as a quorum. So now I hope everybody knows, who is listening my video, everybody knows that what a quorum is. So but for those who do not know what the quorum is, it means that a minimum number of members who should at least be present for a duly convened meeting. So here we are talking about general meeting. So how many minimum number of members shall be present for a duly convened general meeting? So for in case of a public company, the slab is given, that is of 5, 15 and 30. 5 in case the member is less than 1000, 15 in case the member is more than 1000 but less than 5000, and 30 in the case where the member exceeds 5000. Okay, but however, one more thing, that is the starting line of section 103 subsection 1, it says that if the article provides for a larger number. Okay, so if the larger number is provided in the articles, then that number shall prevail as a quorum of a general meeting in case of a public company. So this is a huge deviation from the quorum which used to be there in earlier act, that is 1956 Companies Act. In that provision, it provides that for a public company, the minimum number of member for a duly convened meeting, that is the quorum, shall be 5 members. Okay, so now there is a slab which has been provided, which we have already discussed. Now moving forward, second type of company being the private company. two members personally present shall be the quorum of the meeting. Okay, so what does here mean personally present? Personally present means that not through proxies, but those members should be present personally. Okay, that is physically they should be present over there. Now, secondly, in case of a private company, there is no deviation from the earlier act. That is, the earlier act also provides that the minimum number of members for a duly convened meeting shall be two members personally present, and so is the case with this new act, that is Companies Act 2013. So, I hope the provision of quorum till here it is cleared. So, let's move forward. Now, section 103 subsection 2 provides that now if the quorum is not present, then what shall be the case? So it says that if the quorum is not present within half an hour from the time appointed for holding a meeting, then the meeting shall stand adjourned to the same day in the next week at the same time and place. So now if the quorum is not present within half an hour, this is an important time limit. Okay, if the quorum of a general meeting is not present within half an hour from the time appointed, then the meeting shall stand adjourned. Okay, I hope everybody knows what adjourned means, that it stays suspended. Now till what date it stays suspended? To the same day in the next week at the same time and place. Okay, or to such other date and such other time and place as the board may determine. So it is up to the board. Now, if the board can specify another time or another place and date, then that shall prevail. Otherwise, it shall be suspended or shall stay adjourned to the same day in the next week, having same time and place. Okay, so now this is the case where the quorum is not present within half an hour of the time appointed. Okay, so now the meeting, if it is called by requisitionist, so what those meetings is? Extraordinary general meeting that is called by a requisitionist. I have already discussed it in detail in my earlier video. You can refer those videos for more understanding. So if the meeting is if the quorum is not present for those meetings which is called by requisitionist, then the meeting shall stand cancelled. Okay, so there is no provision for adjournment in case of the meeting which is called by the requisitionist, that is extraordinary general meeting which is called by requisitionist under section 100. If the quorum is not present in that meeting, then in that case the meeting shall stand cancelled. Okay, so let's move forward. Now, what if the quorum is in any other case, that is where the quorum is not present within half an hour, the meeting shall stand adjourned. Now, for that adjourned meeting also, there is a requirement under the law which provides that a notice has to be given to the members. So now, what is the time limit for that notice? We'll be discussing it right now. It says it is given under the proviso. It says that provided that in case of an adjourned meeting or of the change of day, time, or place, if as specified under clause A, as the board may determine, which we have already discussed, the company shall give not less than 3 days notice to the member, either individually or publishing as an advertisement in the newspaper. So now, if the adjourned meeting is called, that is if it is adjourned for the same day in the next week, or if any other day or date is specified, then in both the cases the company has to give at least 3 days notice to the member, and this notice can be given either individually or it can also be published in the newspaper. Now, if it is published in the newspaper, one newspaper shall be of English and other of the vernacular language which is in circulation at the place where the registered office of the company is situated. So now wherever the registered office is situated, whatever the vernacular language of there exists, then that advertisement has to be in English and in that vernacular language. Okay, now let's move forward. Certain things have been provided under secretarial standard as well. Okay, secretarial standard applicable on a general meeting is SS2. It provides that if the meeting is adjourned sine die, which means that if the board has not decided earlier the time and place where the adjourned meeting has to be conducted. So, in all those cases, if the meeting is adjourned for more than 30 days, then the notice shall be as of the other general meetings. Okay, all the provisions of notice shall be like the other general meetings. Okay, but if the adjournment of meeting is for a day less than 30 days, that is, the meeting is adjourned for a day lesser than 30 days, then in that case 3 days of notice shall be given. At least 3 days of notice shall be given. Okay, that could be either individually or it could be through an advertisement. This is also provided in Act, but whatever I have explained right now about 30 days, more than 30 days and lesser than 30 days, it has been given under SS2. You can refer those SS2 for more clarification. Let's move forward. One more thing, it says that again it is the part of Secretarial Standard 2, which says that the meeting could be adjourned either for the want of quorum, which we have already discussed. If the quorum is not present for a half an hour, then the meeting could stand adjourned. Or there are other reasons also where a chairman can adjourn the duly convened meeting. Okay, the other reason is in the event of disorder or the like causes, or with the consent where the circumstances warrant so, or if there is the direction of majority of members. So in any other case, the chairman cannot adjourn a duly convened meeting, only if there is some disorder, or with the consent of the members, or with the direction of majority of members. Okay, in any other case, the chairman cannot adjourn a duly convened meeting. So first of all, the reason is very important, that is for the want of quorum. Other reasons are specified under SS2. Okay, so let's move forward. Now section 103 subsection 3, it provides that if an adjourned meeting also a quorum is not present within half an hour from the time appointed for holding meeting, the members present shall be the quorum. Now it says if at the adjourned meeting also. Now what we have discussed earlier is if the quorum is not present within half an hour, then the meeting shall stand adjourned. But in case of extraordinary general meetings, which is called by the requisitionist, if the quorum is not present, then the meeting shall stand cancelled. So this section 103 subsection 3 doesn't applies to those meeting which shall stand cancelled once the quorum is not present. So it applies only to those meetings which stands cancelled. Which stands adjourned. Okay. So now if an adjourned meeting the quorum is not present. What if the quorum is not present at any adjourned meeting? Then in that case, whoever the member is present, whatever the number of member is present, that shall constitute the quorum. But that number of members should not be less than 2, because we know meeting means at least 2 persons should be present to convene a meeting. Okay. Now one more thing, it says that you can see the term also. Okay, so what does also mean, or how can it be interpreted? It is very interesting if you notice here that the term also is used before a quorum, which says that if a meeting is adjourned for a want of quorum, and at that adjourned meeting, again the quorum is not present. Okay, so the interpretation of the line goes like this, that if the adjourned meeting, the meeting which is adjourned because of the quorum, if at that meeting also the quorum is not present, then the whatever the members are present, they shall constitute the quorum. So here, any other type of meeting which is adjourned because of any other reasons, that is any other general meeting which is adjourned because of any other reason, that is like of any disorder, or as per the direction of the member, or with the consent of the member, then in those cases this section should not apply. But it is only one of the interpretation. Okay, so it is not very much clear over here that what this section exactly wants to cover, but I am telling you only one type of interpretation which can be concluded from here. Okay, just because of one word which is written also. Okay, let's move forward then. Now, one more thing SS2 provides is that at an adjourned meeting, only the unfinished business of the original meeting shall be considered. So, no new business has to be considered at the adjourned meeting. Adjourned meeting is just the continuation of the original one. So, it shall not be deemed as a new meeting. It is just the continuation of the original meeting. However, any resolution that is passed under the adjourned meeting would be deemed to have been passed on the date of adjourned meeting and not on any earlier date. Okay, because the resolution is actually passed in the adjourned meeting, so they shall not be considered to be passed at any earlier date. Okay, I hope this concept is clear and there should not remain any confusion with this concept because it is very simple concept. And I hope and I wish that you have liked this video, and if yes, then please like and subscribe. My YouTube channel is PH Webcam Videos. My concern is just that the basic concepts of Companies Act 2013 should be clear and everybody should be conversant with these concepts. So I hope I am giving my full efforts towards that. And please do not forget to share this video and comment on this video because your comments are valuable, so please do. Thank you. Take care. Bye bye.